Welcome to bongosikha. Today, aspirants, I am going to discuss about the Supreme Court, which is very important to know about the apex court of India. আমাদের সর্বোচ্চ আদালত সুপ্রিম কোর্ট সেই সম্পর্কে আজকে আমরা জানবো। So the Supreme Court of India was inaugurated on 28th January 1950. It succeeded the federal courts in India, which was established under the Government of India Act of 1935. And its jurisdiction, however, was greater than its predecessor, and that is because the Supreme Court has replaced the British Privy Council, the highest court of appeal. So this is the background. Now the constitutional provisions. Article 127 to Article 147 in Part 5 of the Constitution deals with the organization, procedures, functions, independence, powers and so on of the Supreme Court, and the Parliament is authorized to regulate them. Now composition and the appointment. I am coming to this point. Composition, that the Supreme Court comprised of one Chief Justice and 33 other judges, total 34 judges. According to 2019 Act, the center notified in 2019, the center notified that the judges of the Supreme Court will be increased from 31 to 34, including the Chief Justice of India. That is why at present the number of total judges of the Supreme Court, including the Chief Justice of India, is 34. So this is the composition, that how many judges consists of and who is the Chief Justice. Now I am going to discuss that appointment of the Chief Justice from 1950, how the Chief Justice and is appointed in the Supreme Court. So তার নির্বাচন কিভাবে হয়, সুপ্রিম কোর্টের বিচার যিনি প্রধান বিচারপতি তিনি কিভাবে নিযুক্ত হন সেই পদ্ধতিটা সম্পর্কে আমি এখন বলতে যাচ্ছি। From 1950 to 73, the Chief Justice of India was appointed on the basis of the seniority. That is, the senior-most judge was appointed as the Chief Justice of India. But A.N. Roy in 1973 broke this convention, and he became the Chief Justice of India by superseding the then senior-most judges. And again, this convention was broken in 77 when M.U. Beg was appointed as the Chief Justice of India by succeeding the senior-most judge. So this absolute discretion of the government, of the executive, was curtailed by the Supreme Court in the two second judges case, that is in 1993, and the Supreme Court clearly stipulated or clearly mentioned that the post of the Chief Justice, the senior-most judge of the Supreme Court, will be appointed for the office of the Chief Justice of India. So there will be no executive control, there will be no absolute discretion or absolute control of the government over the selection of the Chief Justice of India. Next, that oath qualifications and oaths. So for becoming a judge or the Chief Justice of the Supreme Court, what are the necessary qualifications that I am going to discuss. So first, he should be a citizen of India. Secondly, that person should be a judge of a high court or high courts more than 5 years, or he should be an eminent jurist as nominated by the president, or she should be, or he or she should be an eminent advocate of high courts for more than 10 years. So these are the qualifications for becoming the judge of the Supreme Court. Now that oath of affirmation, that in his oath what he takes, that in his oath a judge of the Supreme Court swears to bear true faith and allegiance, to bear true faith and allegiance to the Constitution, to uphold the unity, integrity, sovereignty of the India, and to duly and faithfully discharge his duties, and to uphold the Constitution and its ideas. So these are the oath what judge when he takes and swears for the office of the judge of the Supreme Court or the Chief Justice of the India, then he takes these oaths. So these are the oaths and qualifications part. Now I am coming to that there are different kinds of judges, that acting judges, ad hoc judges, and retired judges. So, acting Chief Justice, the President appoint a judge of the Supreme Court as acting Chief Justice of India on the following grounds. What are those grounds? That if the Chief Justice is temporarily absent, or if the office of the Chief Justice is vacant, or if the Chief Justice fails to perform his duties properly. So, this in that cases, the Chief President can appoint the Chief Justice of India, acting Chief Justice. Next, the ad hoc judges. Ad hoc means on emergency basis, মানে কোনো গুরুত্বপূর্ণ জরুরি দরকারে খুব তাড়াতাড়ি কিছু একটা কাজ সারার জন্য একটা অ্যাডহক কমিটি, অ্যাডহক মিটিংস, অ্যাডহক জাজ রিকোয়ারমেন্ট, এই ব্যাপারগুলো ঘটে থাকে, মানে অন দ্য বেসিস অফ দ্য এমার্জেন্সি এই ধরনের ব্যাপারগুলোকে কল করা হয়। তো অ্যাডহক জাজেস, when there is a lack of quorum of permanent judges in the to continue any session of the Supreme Court. Lack of quorum means, I told that quorum means that minimum number, in case of Lok Sabha, that 1/10 of the total strength of Lok Sabha, that is the quorum. So minimum number of judges, that is the quorum. If it fails to fulfill that quorum to continue any session of the Supreme Court, the Chief Justice can appoint a judge of the High Court as an ad hoc judge of the Supreme Court for a temporary period. In that case, the Chief Justice of India can appoint any judge of the High Court for a temporary period as an ad hoc judge, and he can do so only after in consultation with the Chief Justice of the concerned High Court and with the previous consent of the President. Previous consent of the President. So next, the retired judge. At any time, the Supreme Court, the Chief Justice of India can call any retired judge of a High Court or Supreme Court to work as a retired, as a judge of the Supreme Court after his retirement also for a temporary period. So this is duly qualified for appointment as a judge for Supreme Court. He can do so only with the previous consent of the President, and obviously the Chief Justice of the concerned High Court. So this is the retired judge. So three types of judges: that acting Chief Justice, ad hoc judge, and the retired judge. So in every cases, the Chief Justice of India can appoint any judge, but with the previous consultation with the President, which is the important point you have to remember. Next, that independence of the Supreme Court. The Constitution has made some provisions in order to ensure the impartial, fair functioning of the Supreme Court. So first is the mode of appointment. Earlier I discussed that from 1950 to 1973 there was a tradition or convention that the senior most judge would be appointed as the Chief Justice of India. The a judge of the Supreme Court is appointed by the President, which means the cabinet and the entire judiciary, with the consent of the President itself. So this provision curtails the absolute discretion of the executive and reaffirms the truth that judicial appointments are not based on any political or practical consideration, because the Chief Justice of the judges of the Supreme Court are appointed by the President. That means the cabinet with the entire judiciary itself, that is the judges of the Supreme Court and the High Courts. So it curtails the absolute discretion of the executive. Next, that security of tenure. The judges of the Supreme Court, the Chief Justice of the India Supreme Court, are provided with the security of tenure, and they can be removed by the President on grounds of proved misbehavior or incapacity by the President only in the manner and the grounds which are provided in the constitution. So then the fixed service conditions, the salaries, services conditions, salary conditions, allowances, emoluments of the chief justice of India, other judges and all the staffs, judges of the India, will not be decreased to his disadvantage, to their disadvantage after their appointment. So that is the except during financial emergency. If there is any case of financial emergency, then these matters will be taken into consideration. Otherwise, the allowances, the pensions, the salaries of the judges of the Supreme Court will not be decreased to their disadvantage after their appointment. So this is the another point which you have to remember. Then all the salaries, all the pensions, all the charges of the Supreme Court of India are charged from the Consolidated Fund of India. Thus, they are non-votable by the Parliament, though they can be discussed by it. So this is another security. Next, the conduct of the judges cannot be discussed. So the Constitution prohibits that not in the floor of the Parliament or in a state legislature, that discussion about the discharge of duties of any judge or chief justice is strictly prohibited, except that judge or his case is under impeachment consideration, is under the consideration for impeachment, then that is different issue. Otherwise, no one can discuss the conduct of a judge in the floor of the Parliament or in the state legislature. This is strictly prohibited by the Constitution. Then ban on practice after retirement. After retirement, no judge of the Supreme Court can plead in any other court or institution in order to prevent it to give favor with the expectation of future favor. So this is the another thing, that they do not favor anyone in the hope of future favor. Next, power to Supreme Court has the power to contempt anyone for the contempt of the court, for its punishment. It can punish, and the action of the Supreme Court or the decision of the Supreme Court cannot be challenged, cannot be criticized by anyone. And next, the Parliament has no power to curtail the power and jurisdiction of the Supreme Court. The Constitution has guaranteed the Supreme Court jurisdiction of the various kinds, so it cannot be curtailed. Next, separation from the executive. The Constitution directs the state to differentiate or to separate the executive from the judiciary in the services of the public matters or in the public services. So these are the all provisions which have been given to ensure the impartial functioning of the Supreme Court. Next, the jurisdiction and powers of the Supreme Court. So, original jurisdiction, writ jurisdiction, appellate jurisdiction, advisory jurisdiction, and a court of record. These all are under the jurisdictions of the Supreme Court. So, first I am going to discuss about the original jurisdiction. As I told in the beginning, that Supreme Court is a federal court. It has replaced the federal courts in India, which was established under the Government of India Act of 1935. So the Supreme Court decides the disputes between different units of the Indian Federation. In broadly, we can say that disputes between the center and the states on the other hand, between the center and two or more states on the one hand and two or more states on the other hand, or between the two or more states. So in the above jurisdiction, in the above type of disputes, the jurisdiction of the Supreme Court is original and exclusive. These two terms are very important, original and exclusive. Why it is important, I am going to discuss that. Exclusive means that no one can here no one can discuss or can again judge this case, such disputes, that no other court can decide such disputes. Exclusive means no other court will be empowered to discuss such matters, and original means the Supreme Court has the power to hear the case in the first instance and not by way of appeal. So in the first instance প্রথমেই সুপ্রিম কোর্ট শুনবে এই ডিসপিউটটা, এই নয় কি আগে লোয়ার আদালতে নিম্ন আদালতে মামলা হয়েছে, সেখান থেকে রায়টা উচ্চ আদালতে গেছে, আবার উচ্চ আদালতের থেকে সর্বোচ্চ আদালতে গেছে, এই রকম ব্যাপারটা নয়। ব্যাপারটা হচ্ছে যে সুপ্রিম কোর্টের কাছেই ফার্স্ট এই ধরনের জিনিসটা আনবে, এবং সেজন্যই বলা হচ্ছে যে অরিজিনাল, the power to hear such disputes in the first instance cannot by way of appeal. ওয়ে অফ অ্যাপিল করে, এটা অ্যাপিল করে ব্যাপারটা নয়, একদম অরিজিনাল জুরিসডিকশন প্রথমেই এটা চলে আসছে। তো এই কারণে এটাকে বলা হচ্ছে এক্সক্লুসিভ, দ্যাট নো আদার কোর্ট ক্যান ডিসাইড সাচ ডিসপিউট, অ্যান্ড দ্য অরিজিনাল মিনস দ্য পাওয়ার টু হিয়ার সাচ ডিসপিউটস ইন দ্য ফার্স্ট ইনস্ট্যান্স নট বাই ওয়ে অফ অ্যাপিল। সো এটা গেল হচ্ছে অরিজিনাল জুরিসডিকশন। Next, read jurisdiction. The Supreme Court, already we know the Constitution has constituted Supreme Court as the protector and guarantor of the fundamental rights of the citizens. So in case of violation of fundamental rights, the aggrieved person can directly move to the Supreme Court. And here the jurisdiction of the Supreme Court is not exclusive. It is original because the aggrieved person can directly move to the Supreme Court. So Supreme Court can hear the case in the first instance not by way of appeal, but here high courts are also empowered to issue writs like habeas corpus, mandamus, quo warranto, certiorari, prohibition. So different types of writs in case of violation of fundamental rights to give justice to the aggrieved person. So that is why it is not exclusive, because exclusive means no other court can decide such disputes. But here the high courts are also empowered to issue writs for the enforcement for the violation of the fundamental rights. So this is writ jurisdiction. Next, appellate jurisdiction. So as mentioned earlier, that Supreme Court has succeeded the federal courts in India, which was established under the Government of India Act of 1935. The Supreme Court is the first court of appeal, and it hears all the cases against the judgment of the lower courts. So it enjoys a wide appellate jurisdiction. What are those? That matters relating to the constitutional appeals in the constitutional matters, appeals in the civil matters, appeals in the criminal matters, and appeals by special leave. So this is the appellate jurisdiction. Next, criminal matters. Next the criminal matters. Now constitutional matters are there, civil matters are there, criminal matters are there, and appeal by special leave are there. So next I am going to discuss about the advisory jurisdiction. So original jurisdiction, writ jurisdiction, appellate jurisdiction I have discussed. Next, advisory jurisdiction. So Article 143 describes or authorizes the President to seek the opinion, what I was discussing, from the Supreme Court of India in the two categories of matters. What are those two categories? On any question of law or fact of public opinion importance, fact of public importance which has arisen or may likely to arise, and on any dispute arising out of the treaty, covenant, sanad, charter, pre-constitution treaty, like that only, on dispute arising on this type of jurisdiction. So this is advisory jurisdiction. Next, a court of record. A court of record is very important to remember, a court of record. The Supreme Court is considered as the court of the record because the judgment, procedures, and the acts of the Supreme Court are considered as a perpetual memory and testimony. So these references are considered as the legal precedents and legal references. They are recognized as the legal precedents and legal reference. And Supreme Court also has the power to punish anyone for the contempt of the court. So this is the court of record. Next, the power of judicial review. The power of judicial review I have discussed earlier also when I was discussing the Lok Sabha, that power of judicial review means the power to examine the constitutional validity of any law. If any law passed by the parliament but the Supreme Court found it ultra virus that is unethical or anti-constitutional, then the Supreme Court can declare such law as null and void or invalid, that on grounds of ultra virus, anti-constitutional. So on the examination, if they are found to be violative of the constitution, they can be declared as illegal, unconstitutional, and invalid, null and void by the Supreme Court, and consequently they cannot be enforced by the government. So this is the power of the judicial review. And constitutional interpretation, the Supreme Court is the ultimate interpreter of the constitution. It gives final version to the spirit, to the content of the provisions of the entire constitution, and the meanings are used in the constitution, what are the terms, different terminology, everything has been described properly by the Supreme Court. So it is the interpreter, it can give the final version of the letter and spirit of the content of the provisions of the constitution. So these are the powers of the Supreme Court. I hope you all have understand the Supreme Court. Thank you.